Firstly, we'd like to thank the committee for the opportunity to present the views of our members in relation to this very important legislation. The Internet Society of Australia, also known as ISOC AU, is the Australian chapter of the Worldwide Internet Society. Our mission is to promote internet developments for the benefit of the whole community, including business, educational, professional and private internet users. As such, we are the umbrella organisation representing the interests of everyone who uses the internet. Many of the organisations that have already appeared here are very closely allied with us and work very closely in that relationship. Our members hold a wide range of views about the way in which Australia can best benefit the internet. However, all of us believe in the fundamentally positive role that the internet is playing and the need for an open, accessible and trustworthy internet. Globally, the Internet Society coordinates the development of internet policy and technical standards. This includes advising the United Nations and the Internet management organisations such as ICANN, the Internet Corporation for Assigned Names and Numbers. The Internet Society is responsible for the Internet Engineering Task Force. The mission of the task force is to make the internet work better by producing high-quality, relevant technical documents that influence the way people design, use and manage the internet. So it's our conclusion that the Internet Society is well placed to offer independent technical and policy advice to the committee and to the government. In a moment I'll hand over to my colleagues who will happily expand on our submission, but please let me begin by restating the position outlined in our submission very briefly. The Internet Society of Australia contends that the data retention legislation as it's currently drafted simply won't achieve the government's stated aims while constituting a serious threat to existing civil rights protections. We understand the government's concern to find effective measures to deal with national security. However, we argue that the bill is deeply flawed, its coverage is unclear, and it doesn't reflect the complexity and diversity of internet communications. It will add significant costs to service providers, which will undoubtedly be passed on to consumers, and will seriously hamper competition. Significantly, it will not reach some offshore communication services widely used by many Australians, potentially providing a loophole capable of exploitation by precisely the groups and individuals the government seeks to target for surveillance. The bill represents a challenge to the right of Australians to the protection of their private information. This has the potential to reduce the confidence that Australians have in their internet use. In conclusion, there are three areas in the bill that are drafted very broadly and which we believe should be redrafted. These are the definition of the data that is to be retained, the agencies and the organisations that will have access to the data, and the grounds on which access to that data will be granted. Now, as I've indicated, we represent and have among our members people with considerable technical and policy expertise, and we'd like to offer that expertise to the committee and through the committee to the government, and we would respectfully ask the committee to encourage the government to take up our offer. Thank you.
Thanks very much.
Yes.
To the government?
Yes, to the Attorney-General's staff, yes.
I don't know whether anybody else wants to have a go, but I've only got one other question. Is offshore operations the only loophole that you actually identify? I mean, I would like to see, I don't know if I want to publish it, but I don't necessarily want to draw attention to all the people of concern, what those loopholes might be.
Not us, which is why which is why we're offering to work with the committee and with the government. Well, I don't think we really necessarily need to highlight the inadequacies.
Well, I would be interested in identifying the areas that you think the legislation does not cover.
We could take that in confidence. Yes, in writing, in confidence.
May I talk in confidence?
No, this is a public hearing.
At the moment it's being
published.
Yes, a brief overview.
All right, a brief overview, and I think my first comment is, given many of the technologies that exist now that are not well accommodated by 97 legislation, that's 1997 legislation, there are going to be some loopholes. Now, the loopholes that are already in our submission, and therefore are public anyway, some of it is about drafting and, sorry, I'll speak more slowly. Some of the problems are simply about drafting, and they can be easily corrected. For example, the drafting about the service providers covered. Well, the way it's written now, it looks as if it's only carriers as infrastructure owners and ISPs, and that leaves all providers of telephony that don't also provide internet access not covered by the bill. That's not intentional. You read the Attorney General's submission, they don't believe that's what they've come up with, but they have. I don't understand that, but bad drafting. Another is an immediate circle, and really this is an answer to your question to ACAN, which is who's covered. Now, the explanation in the Attorney General in the explanatory memorandum is it will be difficult to unpick the commercial relationships that underpin what's conceptually an intermediate circle as defined in the Telecommunications Act. Parliament House is an immediate circle. The Commonwealth Bank and all of its branches is an immediate circle. Libraries, universities are immediate circles as defined in the Telecommunications Act. And in that situation, they are provided generally by a service provider under contract with a particular firm. So those are, in one sense, commercial agreements you don't unpick. Another aspect of that definition, which is involved in the term supply to the public, which is section 44 of the Telecommunications Act, that's the reason some of the cafes are just plain not covered. So we're dealing with, in some cases, definitions in the Telecommunications Act that mean some areas are not covered. Now, if you read the Attorney General's submission, they're relaxed about some of that. They understand the difficulty in covering some of this. But in some of the drafting, I think the drafting could be better to close some of those loopholes. So I would be completely happy to go through and say, clean up some of this wording.
Can I ask a follow-on on that?
Yes.
And I've just asked for the bill to be brought to me. The data retention bill refers to carrier, but it's then further defined in the Act, a carrier within the meaning of the Telecommunications Act, a carriage service provider.
I will explain why there's a difficulty. Under Section 5 of the
Sorry, I can't hear you.
I have a soft voice until I actually lecture. Under Section 5 of the Telecommunications Interception and Access Act, the definition of carrier is said to include carriage service provider. Now, okay, that's a choice that the drafters have made. But then when you come to Section 187A, where this is the bill, then the bill is said to cover carriers and internet service providers. Now, if they just said carrier, you could say, okay, that definition covers carriers and carriage service providers. But because they've said carrier and ISP, as defined under the Broadcasting Services Act, the way a lawyer would read that and the way a court would read that is, well, why haven't you used the term carriage service provider? That's what's in the Attorney General's submission, that term, but it's not used here. And so the mere drafting, the way it's been drafted, they have not used the very definition that's in the Act, which I don't understand. I mean, I read this and went, I do not understand this drafting.
Thank you.
Okay.
And there are other examples that you could give us in writing, and where it's undesirable that we in fact publish them to draw to others' attention that these may be the loopholes they could avail themselves of.
My pleasure.
All right. That would be...
George, if you've got an example?
No, just for the benefit of Mr. Ruddock, we were talking prior to this, and you were talking to my colleague Narelle Clark about the uncertainty about Wi-Fi cafes, internet cafes and things. The Attorney General's paper on submission on page 24 reads that second, data retention obligations will not apply to services that are provided only to a single place or to places in the same area, such as free Wi-Fi access provided in restaurants, libraries or a campus. This exception reflects an assessment of that the law enforcement and national security benefit of imposing data retention obligations on these services would be outweighed by the privacy and compliance burden. The paper goes on to say that, however, some key non-content data relating to the communications made from internet cafes will be retained by the internet service providers supplying these services to the internet cafes. This will assist with any authorisation requests issued by agencies seeking advance in their investigations. Now, my role in the Internet Society on this particular issue in the task force we've set up is primarily technical. But one of the things I look at also as a service provider myself in my private capacity is the fact that the legislation contemplates a situation where, as a service provider, if other people are providing those services, I don't have to collect the metadata in relation to that. Now, the problem with that is that in the case of Wi-Fi, is the cafe providing the Wi-Fi access, or is the service provider themselves providing the Wi-Fi access? If it is the latter, then it's likely that they are responsible for picking up the metadata. If it's a case where the cafe owner is operating it, then in that case, the service provider has no obligation to collect the data. And of course, the cafe is not a service provider, so the data is effectively, in that particular case, not collectible. Now, that's a fairly well-defined example in the case of a cafe, small, quite isolated. But when you get into the position of looking at supermarkets and university campuses and things like that, we're talking about much larger entities here, and where effectively you're running, in the case of a university campus, it's almost a small city. We'd regard that as somewhat of a loophole that should be looked quite closely at. The prospect of a number of different providers as well at a much more serious level could result in the fact that that data is not being collected. If I can give you an example of corporate services, many people are aware of the fact that corporates run their own mail servers, and in that particular case it is possible, the way that the legislation is drafted, that internet service providers are providing the connection but they're not actually providing the service at the end, which means that internet service provider or carrier doesn't have to collect the data. Now, this is a predicament that I'm faced with as a small provider. Again, there's the same problem. The corporate exchange server that might be at the end of that, there's no obligation to collect the data there, so the service provider sits back and says, well, I don't have to collect that data. The variables in terms of those types of scenarios are quite significant, and we believe that in the old traditional legal sense you could possibly drive a cart and horses through a number of different scenarios which would cause some issues, especially when it comes to public Wi-Fi access. So that sort of technical issue I think can be resolved in the legislation, but what needs to happen is there needs to be some technical consultation with people like ourselves to work out what those issues are. Another example is, for instance, the collection of logs. One of the things that our little operation does, and we are a very small operation, is have mail logs. In the case of mail logs, 90% of any email that is sent to our system is rejected as spam. And the reason that it is rejected is because there are what are known as real-time black hole lists around the world. Now, those black hole lists are fairly simple. They're a list of IP numbers that are updated hourly. So if a piece of mail comes to our server and they knock on the door and say, we'd like to deliver the mail, the first thing our servers do is check against the database. Is this person a spammer? And we will know by the IP number. If that person or that piece of mail is from a known spam source from those databases, the mail is rejected. It never reaches our system. But the metadata with regard to the actual instance of that negotiation is kept. Now, our mail logs, 90% of our mail logs contain information about spam. Some of that metadata includes URLs because the spam providers will very often say, if you want to check as to why that's been rejected, in the header they will actually put a URL in. Now, under the legislation, it isn't required that that URL, in fact, the legislation specifically says we are not collecting URLs. If that is the case, then if an enforcement agency came to my office and said, well, we need to see your metadata, part of the problem is that I will have to separate that data out from the logs. And that is a not insignificant technical task given the amount of data that is generated, metadata is generated, 5 to 6 lines a second in some cases at peak hours during mail services. So there's some technical issues there we think that need to be looked at very seriously because they have practical implications as to whether the law can be enforced in a practical way. And as my colleague Laurie has indicated, the Internet Society is very keen on being able to sit down, perhaps providing some of that technical assistance in that process.
And in terms of the timing, what you are referring to are amendments to the legislation,
yes,
not the subordinate regulatory arrangements. You couldn't fix it through regulations, could you? Are you talking about amendments to the legislation or matters that we could deal with through... I mean, regulations are going to come later, and in terms of whether we want to get the legislation through in, say, 2 weeks' time, when the Parliament's back...
I think we're looking at the big picture here. I think within the regulations themselves, within the bill itself, there are some fundamentals that have been set up that are possibly going to be difficult to fix by regulation. Some of those fundamental processes need to be addressed first before we can then move on to regulation to say, yes, we can do that. And again, an example of that is what data is captured, who is a service provider and who is not, and if that service provider is providing a service that just happens to pass the packets through, who on the other end is caught. I suppose I'm looking at where the government is. The government wants to get this through, yes, when we come back. And they want us to report on it. And I'm anxious that we should look at the issues you are raising, but I don't necessarily want to see the whole legislative package derailed. So are these matters that we could look at through further amendment?
Yes.
I think, Mr Chairman, some of the things that we're talking about are certainly in that category, but I think there are some fundamental parts of the bill that are beyond being sorted out by regulation.
I think, let me first answer your question. In terms of just the coverage of carrier service provider, 2-sentence correction to the bill, and there would be things that are in the bill now that could be changed in the bill, and those could be easily forwarded. I think some of the other issues we have are perhaps, yes, the bill could be amended. There are perhaps more. There would be more implication to doing that. Some of the difficulties, for example, we are talking about. I have to say, a very badly worded section in the bill that talks about, I think, excluding providers that are based overseas, but I think the infrastructure is here. Now, I've read that sentence about 5 times and I've come up with about 3 meanings. It's not clear to me. I'd like to redraft it once I understand it. My impression will be it will be difficult for this government to actually regulate some body that is based overseas. However, you can incorporate regulation for an entity that has a basis in Australia. You could redraft the sentence that is here to make it clear what you're after and make sure that it's possible to get the bodies that in fact have a presence in this country. And how you do that, for example, the Broadcasting Services Act has some hints on how you do that. So there are things in here, the bill, that could clarify how you would address the issue of somebody that may be based overseas but also here, recognising that if there's a completely foreign presence, you would have a jurisdictional issue, and we realise that that's a hole which will be difficult to plug if there isn't an Australian presence. So then you'd look to, say, the Broadcasting Services Act, where in fact the provisions in that talk about cooperation with overseas agencies as the way to deal with that. So there are those sorts of things that you could do with this that would improve that.
I hear these points, and now I go to the question of how you made your offer to the government. I mean, did you speak to the minister and he said, "Oh, look, I'll have somebody talk to you," or did you put it in writing? Have the people who are drafting the legislation turned their mind to these sorts of questions you have raised? I'm just trying to get how you've made your offer.
The answer, sir, is that I have emailed the Deputy Chief of Staff to Senator Brandis.
And we would be happy to follow that up.
That's right. We are also in constant...
And has somebody talked to you after that email?
No, I haven't heard back yet.
And how long ago was it?
Would have been late last week, I think, from memory.
Late last week.
But we've had previous meetings.
So a week ago. Late last week is a week ago.
So we've had contact with the members of staff and some members of Parliament on both sides of the House to offer our assistance where we can on a regular basis, and that's gone back probably over the last 3 to 4 months. We've spoken to Mr. Terminal's office, his Chief of Staff, and we meet him regularly. We have, in fact, we did in fact spend some time in August writing 10 questions with fair detail of explanation as to what we were asking and why about the legislation, and we did follow up and ask if we could address those issues and perhaps discuss them. There has been communications on both sides of the House for that, and the responses have been variable. I understand it's a busy time in Parliament, and obviously not everybody can be seen, but at the same time we have made concerted efforts over the last 3 to 4 months to ensure that that an even-handed approach to all sides of the House has been made, and an offer to assist where we can has been made at that level.
Have you approached any members of the committee?
We just have.
No, I was just saying before, you're saying that you've been in contact
Yes.
for the past. You have?
Not specifically in relation to this hearing,
Yeah.
but we are in
about the
general,
issues.
we are generally in conversation. If I could just make the point that apart from myself, the organisation is staffed by volunteers, and so we've spent a considerable amount of time, particularly Ms. Raish, in writing the document. It really was very late that we got the document finished, and it was really, to come back to your point, Mr. Ruddock, it was really only last week that I think we came to the conclusion that the best thing we could do was to offer the technical advice from the committee.
And you've written to the Minister, and at this point in time, the people who are in the department who draft these matters and are across them may not have even turned their mind to the issues you are raising.
No, and that's why we're keen to offer our services.
And I suppose my question goes, if the government is keen to get this through initially in 2 weeks' time, can these matters be dealt with by further amendment later?
We don't report till the end of February.
Don't we?
No.
So you're not going to get it through for next week?
We report.
I'm a bit disappointed in
We
this.
report by the end of February.
Oh, this is outrageous.
Government whip.
Yes, unless the
I thought this legislation was urgent and pressing.
unless the chief government whip has taken matters into his own hand that we're not aware of.
Well, if I was the attorney, I probably would have.
So the essence of the point we're trying to make is that we are keen and available to assist. I mean, we have, as far as we have been able to do so, been frank and honest in terms of our own opinions and concerned. And certainly the Internet Society is not made up of just the three of us here. There's a board of 13 and other members, and they've all put their hands up to say we
If you
can
hadn't
assist.
gathered, your submission impresses me greatly. Now, I'm fairly naive about these matters, but it does impress me greatly, and I would be encouraging people to speak to you as quickly as possible. I mean,
Thank you very much.
That's where I come from, maybe informally, but they seem very cogent and very appropriate to be considered by me.
Just to back up what Mr.
But I'm
Ruddock's
fairly
saying.
naive in these
No,
matters.
it's not really. But just to back up what Mr. Ruddock's saying, if you could give us also, in addition to what you might
might give the committee a document to the chair, he can distribute that, then we can actually make sure that that documentation is passed on to the Attorney General's department and office as well. So just sort of two measures. But with Mr Ruddock, we're quite impressed with what we've heard. Very keen to hear more from you.
I would have, with respect, we're happy to do that, but I would have thought that as a starting point, our submission is fairly detailed.
Yes.
And I think our submission would probably prompt a two-way discussion. I think, we're certainly happy to provide more information. We're happy to provide people to come and speak and discuss matters. But I think, in the first instance, I think it would be good if the committee could pass on to the government the suggestion that they might read our submission in preference to some of the others.
I think you can rest assured that after the evidence you've given today, they would. I think it would be extremely embarrassing for the government if legislation passed the Parliament and then evidence that was given to this committee before it was passed was subsequently revealed to be correct, that there were loopholes, Mr Fong, that you described you could run horses through. So it's in the interest of good public policy that these concerns are brought to the drafter's attention. Tomorrow the Attorney General's Department will be before us, and one of the questions that I'll be asking them is, are you aware of your submission and their initial thoughts on it, and whether they intend to sit down with you and go through those concerns that you've identified and see if they can be addressed prior to, one, this committee reporting, and two, the bill being debated in the House.
Could I just repeat? There are things that can be fixed, but there have obviously been some policy decisions in respect of whether or not you really want to go after companies in foreign jurisdictions, how you would want to do that. And I guess my suggestion, I repeat, is the Broadcasting Services Act does suggest a way. Immediate circle is another issue that the attorney's submission said, yes, we know this. Now, the examples they gave were, well, libraries and universities already cooperate with us, but we're not talking about just libraries and universities. We're talking about any big corporation. So it's not, it's a larger problem than was suggested in that submission. We're talking about every large corporation will have its own network, and that's a private network. Now, it then becomes a policy choice. Do you want to unravel some of those circumstances? You have in the bill allowed for the identification by the communications coordinator to name immediate circles if there's a problem, and that may be sufficient, but I would say, well, maybe there's a test that surrounds that could be strengthened. There are things like that where a policy decision may have been made. I'm not sure it's been made well, and I'm not sure the alternatives have been thought through. And those are the things that, when I was reading it, were troubled, frankly.
Mr Chairman, just by way of a concluding remark, if I may, I've only just recently taken on this role, and the Internet Society is in a process of, I think, increasing its profile. What we would hope that in a situation like this, if it were to occur in a year from now, that the government and the members of Parliament that are particularly interested in this subject would in fact come to us long before we get to the point of going through a bill and identifying its weaknesses. We'd like to be in a position to be able to provide strategic advice as well as detailed technical and legal advice, and we have the capability to provide that.
Okay. All right. Are there any further questions?
No, I just want to say thank you very much. I found it extraordinarily helpful.
Thank you very much.
And if there is a possibility for that confidential information, that would be...
We're very big on confidentiality.
Yes, that would be good. So thank you for giving evidence.